But what you have to realize in Louisiana is no, no, no. At your own death, in that first level of like passing the assets, by giving everything to your spouse, you are effectively legally disinheriting your kids at that step. All right. Hello, everyone. So I think for the first time in the Practical Planner's history, Thomas is not hosting this one. I am. And so this is Ann Rhodes, the Chief Legal Officer at Wealth.com. And today we have a very special episode. We have invited an estate planning attorney, Addie Prewitt, who practices out of New Orleans, Louisiana, as well as Alaina Lacter, who is Senior Product Counsel here at Wealth.com, to talk about Louisiana planning specifically. Now, for those of you in the audience, lots of financial advisors, of course, but maybe even clients, you know that Louisiana has been for a very long time a state on which Wealth.com, we would say we don't offer trusts. For a long time, we took our wills offline because we wanted to make sure that sub-trusts or planning for blended families could be done appropriately. And so finally, earlier this year in January, we released our Louisiana will workflow. Now, we did not release a trust workflow, and this whole episode will be sort of about the intricacies of Louisiana law, what makes Louisiana just so special in the estate planning world, and the decisions that we decided to make here at Wealth as well. And so without further ado, I'd love maybe Addie for you to introduce yourself first to the audience, since you're our first guest who's an attorney in a very long time on this podcast. And then Alaina, for you also to have the chance to introduce yourself.
Sure. I'm Addie Prewitt. I'm an estate planning attorney in Louisiana. I've been practicing in New Orleans for the last 10 years, have some experience in Big Four accounting firms, and kind of eventually found my way over to estate planning. I'm with Farrah Law Group, and just really excited to be with you guys today.
Thank you so much.
I am Alaina Lacter. I am Senior Product Counsel at Wealth.com. I joined Wealth in 2024, and before that, I was in private practice in Seattle, Washington. So not a Louisiana law expert, but I've been working with Addie a lot over the last year, so I feel at least somewhat well-versed, but I'm excited to talk about it all today.
Well, welcome, Addie and Alaina. So today we have three women with a first name starting with A. Hopefully that doesn't get too confusing for our audience. But Alaina, why don't you kick it off?
Great. So like Ann said, we're going to cover some of the nuances of Louisiana law today, some of the things that are the same in other states in the United States, and then some of the key things that are different. And just to start it off, I thought I would do like a quick glossary of like some of the big terms that differ in Louisiana from the rest of the country. So instead of a will, a Louisiana resident might say
testament. So that's usually what most people refer to around here.
Okay. And then instead of probate,
this is the most confusing one, succession. We call it a succession here. Everybody's seen Succession on HBO, so they totally are confused. It's not at all like that. It's just what we call probate.
And then instead of guardian for a child.
Sure. We call those people a tutor, which nobody in Louisiana even knows unless they're a lawyer, I feel like.
Okay. So not a math tutor, although they might be good at math.
Yes.
And then instead of a life estate, you might say.
Right. We have this weird term called a usufruct. And so we're going to talk about that later, but it's a little different.
Yeah. And I know it's not totally one-to-one with a life estate, but we'll dive into that. So one of the first things that we mention when people ask, like even internally at Wealth, like how is Louisiana different? We say like forced heirship, that is different. So in the rest of the country in general, you can choose to completely disinherit your child and give them $0. Is that true in Louisiana?
The lawyer answers it depends, but in general, we have like this concept called forced heirship. So, it goes back to our civil law, Napoleonic Code, all that stuff you hear about when you think of Louisiana law. But it's been reformed, so it doesn't apply to all children. It's only children who are either under the age of 24 or any child, regardless of age, if they are permanently incapable of taking care of themselves. And that definition can be very broad, so there's lots of nuances that can come into that.
Okay. And so how much, if somebody does have a forced heir, like what does that mean for their estate and how much they can, how much they have to give that forced heir?
Right. So if you have one forced heir, you're required to give them 25% of your estate. If you have more than one forced heir, it's 50%, but then divided by the number of children. So if you have two, it'd be 25 each. If you have three, I went to law school, not math, but you kind of get the picture. So that 50% is divided amongst the number of children that they have.
Okay. And so I know that like it's pretty rare that somebody would want to completely disinherit their child, although it does come up. If somebody does want to disinherit their child and they do fall within that definition of forced heirship, or they think they do, are there options like to disinherit a child?
Yeah, there's a statute, what we call our laws around here that directly addresses the circumstances where you can disinherit a child. Probably the one that we see the most often. I think for kids under the age of 24, it's pretty hard. But for adult children, refusal to talk to a parent for 2 years despite knowing how to do so is like a big one. I mean, this is going to sound crazy, but attempting to murder your parent is grounds for, disinheritance, which would seem obvious. So there are ways to disinherit a child. But I think the biggest thing to kind of remember about forced heirship is, for minor children, as a parent myself, not many people want a let's say 8-year-old to get 25% of their estate outright. And so to put it into trust or a different form, you kind of have to jump through all these hoops. So that's where, even though, I think most people are like, oh, that's a great concept, you take care of your kids, but it can kind of lead to some different results than you might think. So.
Right. And I think about this too, because I think the idea that a lot of at least traditional families have is like, oh, I want everything to go to my spouse. And then after my spouse has passed away, then everything goes to the kids. But they like want their spouse to be cared for, and they think that just like the default laws of their state are going to take care of that, and that's not necessarily the case.
No, that's exactly right. And in Louisiana, in particular, whether property automatically goes to their spouse depends on whether it's community property or separate property, which most people don't think of. We're a community property state. Most people, at least that I deal with, don't have prenups, don't have any marital agreements. So they think like, okay, it's our house. Like when I die, it goes to my husband. But that is absolutely not the way it works here. So, you can think of it as when you die, my husband will get his 1/2 interest of the house, but I can give my 1/2 interest to whoever I want. And so people, they just think it's like joint tenants with rights of survivorship, and it's not.
Yeah. And that's actually like, even though it's a difference in a lot of states, I think Anne and I can probably like relate to that at some level because we both have practiced in community property states, me in Washington and her in California. But I do think people have that expectation, especially if they have like some awareness of what community property is, but maybe not full understanding. I feel like that's a logical assumption or like conclusion to draw when you hear like, oh, community property, what's yours is mine. What's mine is yours.
Exactly.
Yeah.
Yeah, I think for me, what was so interesting when we were releasing the will workflow at wealth.com and why Louisiana ended up being so different from some of the other states is this idea of like disinheriting your kids. You think, oh, that's only really relevant once my spouse has passed away, right? Like, oh, maybe that's when somebody's considering like disinheriting. But what you have to realize in Louisiana is no. At your own death, in that first level of like passing the assets, by giving everything to your spouse, you are effectively legally disinheriting your kids at that step.
Right.
Which is kind of like weird, and so all of a sudden, even the structure of our documents had to change to accommodate that. And Addie, I was wondering if you could talk a little bit about Alaina mentioned most people don't think it's a good idea to give 50% of your estate split amongst like your 2 or 3 children who are minors.
Right.
And so what do you do if you want to override that like, disinheritance of your kids and put more assets in the hands of your spouse? Like, what's the mechanism there?
Yeah, that's a great question. So there's two ways that we do this. Two ways the law allows us to do this. So the first is to use a usufruct, and we've kind of already mentioned that term before. It's similar to a life estate. It gives the person, the person who receives the usufruct, we call them the usufructuary, and they have the right to use the property and the right to derive the income from the property. So, if you think of if you're familiar with life estates, that's generally what you think of. So we can give their surviving spouse that usufruct, that ability to use the property, and then the children are the naked owners. That's just what we call the remaindermen here. So the property kind of automatically goes to them that way. Now, to kind of throw another nuance onto it, if you think like, I have minor children, what if I die and then something happens to my husband and the kids are still minors? I probably still don't want them to get it. So what we'll typically do is create the usufruct structure, but then put the naked ownership interest in a trust, so that if something does happen, the trust is there to automatically like step in and say, here's where we're going to make distributions, here's when we're going to terminate, who's going to oversee that trust. And so, sometimes I say estate planning in Louisiana is like, estate planning with one hand behind your back, because you're going to have to jump through all these hoops. Eventually, I think we get to a lot of the same answers as in other states, but you kind of have to work through the statutes to get there.
That's a really good point. And that's actually that's the route we ended up taking with our wealth.com documents, because we, always in other states, we give users the ability to decide whether or not they want their child's share to go into trust. But adding on this layer of like the usufruct and having that testamentary trust come into play at the first death, if forced heirship is potentially applicable, that can, it just kind of changed how we thought about things, and we couldn't just, copy and paste from other states, because there was a little bit of like reworking in how we all like tend to think about that in the process of estate planning. So it's really interesting. And I know I laugh at the naked ownership comment because our paralegal thinks it's the funniest thing that it's called naked ownership.
I have no clue why it's called that. It's so everybody is like, what are you talking about? The term naked, and they're like, what? So
in other words, if you read a Louisiana will, or, I guess a trust, and you see all of this really weird language because you yourself as an advisor are not used to having clients based out of Louisiana, it's actually a hallmark that the document is a higher quality one, because it's trying to be respondent to, this weird dictionary being used in Louisiana.
Yeah.
And so don't be put off by the term naked owner is the bottom line.
Absolutely.
That actually leads to another question I had, and I know like we've talked about this a little bit in the past, Addie, but I was wondering like how much this actually comes up in practice when this isn't accounted for in someone's documents. I think about like in my family, if everything went to my mom, I wouldn't bat an eye, because, I think that's the expectation of a lot of kids too, like that their parent in a traditional family is going to have access to those dollars. But like, are there disputes over forced heirship?
Most definitely. There are definitely disputes. And one thing to kind of keep in mind is in Louisiana, usufruct is not just over real estate. So you can have a usufruct over bank accounts, over financial accounts, a car, like anything, any property, you can have a usufruct over. And so if you don't actually have a will in Louisiana, the default is the surviving spouse gets a usufruct. One big difference between a usufruct and a life estate is that it can be for a set term. So the intestate laws say the usufruct lasts until remarriage or until death, the earlier of them. Mm-hmm. So it could actually terminate before the spouse dies. So anyway, to get back to your original point, I think the way most of the time we see the forced heirship issue come up is maybe a blended family situation. So surviving spouse is not the parent of the children. They didn't get what they thought they were going to get, or not as much. And the kind of the interesting thing is we said that, children under the age of 24 automatically forced heirs. Like, that's very easy. When's their birthday? But for the other kind of prong of the statute, as you will, the statute says that if they have an incurable disease that may later render them incapable of taking care of their person, they can also qualify as a forced heir. So you can imagine, like, I've seen people claim diabetes as, being the forced heir. They may eventually be rendered, incapable of taking care of themselves. And so, I mean, depression, like, just there's lots of things that can come up. So I think that's particularly when we see it. And because the statute is so broad and doesn't give a lot of guidance, the courts are still just always interpreting it. So it's, rather interesting in that sense.
Yeah. Well, one more thing about I know that there's probably a lot we could talk about with usufructs, but one question I do anticipate that people would have is, like, a usufruct is kind of an informal trust in a way, right?
That's
And
exactly
so,
how I think of it.
like you said, the spouse has the right to the income, and they like have the right to, if it is real estate, live in the house. But they don't have the right to sell in the house. So, like, what does that mean practically? Like, if somebody wants to move, do they have to ask their kids permission? Like, what does it mean if a spouse, like, uses up the whole bank account, to, like, care for themselves, which might have been the intent of the deceased? How does that all kind of shake out?
Yeah, great question. So I think it depends on the type of usufruct. So sometimes for the wills that I'll write, sometimes you can give a usufruct that allows the person, we call it the right to convert the property non-consumables to something else. So they can sell the property, they could sell a house, and then whatever proceeds, the usufruct attaches to that. So a lot of times, like in a lot of documents, you'll see, essentially to give the surviving spouse the right to sell the property. Now, if we're talking about the legal usufruct that comes under the inheritance law, then they don't have that right to sell the property, and then they need the naked owners, the kids, to sign off on it. In most families, that's not a big deal. But as you can imagine, in some families, there is some money that has to be transferred in order for that, sign off to occur. So,
Yeah.
kind of depends on where the family is in that situation. And then I know you
Yeah.
had another question that I wanted to answer, and I can't quite remember what it was.
Yeah. So if it is a consumable, say they have a right to sell the house, and that's something that we did grant in our wealth.com documents. Like, when a spouse is given a usufruct, they have the right to convert to avoid situations like that. But if they do sell the house, or if the usufruct is granted over just a bank account or stocks or something else, and they use it up, what does that mean for the naked owners?
Yeah, so that is a great question. Essentially, when we think of a usufruct of a consumable like a bank account, under the law, technically, what they should do is open two accounts. They should put sort of the principal in one account and sweep the income over, because the usufructuary at the end of the usufruct has a obligation to account to the naked owner for the money they received. Now, as a practical matter, do people do that? Absolutely not. And there is really no way for the naked owner to tell them to do that. So essentially, the naked owner has become an unclaimed creditor of the surviving spouse's estate. And that's usually what I tell people. Like, this is how we should do it. Now, whether they do it the way I say, flip a coin. But at the end of the day, the naked owners don't have a lot of recourse. I mean, if the surviving spouse had real estate or whatever, they would have the claim on, like they're an unsecured creditor of the estate, essentially. So if they use up everything, sometimes there's just nothing there to go get.
Wow.
Yeah, crazy.
Very informal,
Yeah.
which is fine. There are no issues.
Yeah, and so I think your comment, like an informal trust, is just a great way to that's the greatest way I think about it, because that's what it is. I mean, we're kind of separating ownership. We're saying who can do what. The law tells us the rights of the usufructuary and the naked owner, but at the end of the day, it is very less formal than a trust. A trust gives much more structure around that, and I think for a lot of people, like exactly what you said, they really do want the surviving spouse to use up the proceeds and not have to account, and just whatever is left go to the kids. And so when, the way to do that is a testamentary trust. And so usually I will try and convince them to do that, but they see trust and they get scared, and it doesn't always work. So
Yeah. Okay. Well, speaking of trusts, that leads to my next question.
Okay.
I feel like, just like the will versus trust question. It does vary by jurisdiction. I practiced in Washington. Jumping to a revocable trust was like definitely not the default, that it can be in other states that have, a particularly expensive probate process. But what does that look like in Louisiana?
Yeah, I think we're kind of the same. So the default rule here is not automatically a revocable trust. We don't have a terrible probate process. So, when people kind of come to me, generally my advice is that a last will and testament, is usually where we start. Now, if there's circumstances where that doesn't work, and there certainly are, then a trust kind of comes into play. But, I get I saw on YouTube or this TikTok video said I need a trust. And so when people tell me that, I'm like, okay, well, why, what are your assets? Why do you think you need it? Like, let's talk about specifically what it's going to do and what it's not going to do. And I still think people have the misconception that once you put stuff on a trust, like it's just tax free. And so, like explaining to them that a revocable trust really doesn't provide asset protection or, doesn't protect you from actually, it's sort of interesting. So,
Addie, I will tell you, part of the impetus of this podcast is to demystify a lot of the things people are hearing on TikTok and other social media sources.
We're on the right track.
You reiterating that, I am a thumbs up for it. And I encourage our audience to check out earlier episodes of this podcast where we say there is no income or estate tax planning objective being fulfilled by a revocable or living trust.
Say it over and over. Maybe they'll get it.
Yes. And for like our wealth.com documents, like for that reason, we're like, we already know that we're going to have to deal with a lot of the complexities of like Louisiana law in general with dealing with our testamentary trusts within our last will and testaments. So we went the will route but just to like talk about that, we still did have to think about Louisiana law in terms of trusts and how it differs from other states. And one of the things that like popped out to me when we started talking about it was just like overall the flexibility is much more limited. And I was wondering if you could expand on that a little bit.
Yeah, absolutely. So one of the biggest things I think in terms of flexibility is in Louisiana, we kind of divide our beneficiaries between an income beneficiary and a principal beneficiary. And I kind of think of it as like the principal beneficiary is king, like they're the anchor of the trust. So it's very hard. It's not impossible, and there are certain circumstances. But once you name those principal beneficiaries, that's ultimately who's either getting or estate is getting the money. Now, one thing that we don't have is that to be named a beneficiary of a Louisiana trust, generally you have to be in being. And so you can't have these super long, just, descendants of forever and ever. Like we don't have dynasty trust. When people are like, I want a dynasty trust, I want multi-generations. First off, I'm like, well, do we really need that? But B, if you do, the Louisiana jurisdiction is just not going to accomplish your goals. It's just at most 3 generations is about all we can get if we use a class trust, but that's really about as far as we can go.
Yeah. And I know that was like something that when you were helping me review the documents, that was something that we were like taking a look at our wealth.com documents, making sure that we like have a clearly defined principal beneficiaries, because that's just not what our forms look like for different states. That like identification of income and principal and having that be set, because even if you have, my descendants then living, that can run afoul of the Louisiana law.
Exactly. And then another thing that, we have no powers of appointment. So after I graduated from LSU Law School, I got my LLM at Boston University. I get into estate tax class, and people are talking about powers of appointment, and I have no clue what they're talking about. Like, I'm just like, what is this thing? Like, please explain. And so I think people probably think that's hilarious because like that is one of the most used techniques of estate planning everywhere else. And we just have no ability to do it here. So that's very different.
Yeah, if you go to a Hackerlink session, I wonder how many sessions do not mention the power of appointment.
Probably zero. So that's, there are definitely, I remember I had to go buy a little trust book because I was like, I don't understand. This is so different. It's good though.
I'm trying to think of what else we want. Okay. So this was one thing, and actually mentioning our paralegal again, when we were working on this Louisiana project, I kept saying like, oh, Louisiana law is different. Louisiana law is different. And she was like, Alaina, you need to stop saying that because people in Louisiana don't see themselves as different. It's just their lives. And she's right. I'm sure she's right to some extent. But I was wondering like what level of knowledge and awareness the clients you see come into your office with this, or like how much you need to explain these concepts to them. Like, are you starting from scratch, or is there some baseline level of awareness?
That's a great question. I mean, even I'd say like when I went into law school, I didn't realize anything about forced heirship or, I knew we had community property. So I think for most people that come in, if they haven't been involved in like a succession of their parent or grandparent, they really don't have a lot of experience with it. And so it is just kind of educating, kind of starting at the beginning and explaining how the rules work and how, how we can, I don't say get around the rules, how we can use the rules to do what they need to do. But it's definitely a lot of education, ongoing education.
Yeah. Which makes sense because I think that's true in any state, and like people see what they see on TV, like we were talking about. It looks like this like grand thing, and then actually it's just a lot it's paperwork and administrative.
Right. And the reading of the will, that's my favorite. They're like, when are you going to read the will? I'm like, I've never read a will in real life, So it's not like you see on TV.
So many novels, like the inheritance is conditional on something crazy that would never actually be enforced. So I always laugh at that if I'm reading my chitlet novels.
Yeah.
But I think we've covered a lot, but I think just in general, are there any other misconceptions about Louisiana estate planning or just estate planning in general that you see come up in practice that you feel like we should debunk a little bit?
Yeah, so I think we got most of the big ones. I think, and you've kind of already mentioned this, I think, most people just leave everything I'll leave everything to my spouse and they'll take care of the kids. And so, I do always caution people like, in Louisiana, there is no ability to, once you give it to somebody, there's no condition, they get it. It's outright ownership. They can do what they want with it. Grief, like second spouses, you never know. So I think that's a big one that people don't often realize. And then I think it's also, another one I hear a lot is I don't have my estate's small. So like, I don't need estate planning. And so I think in that sense, it's trying to let people know that estate planning is more than just a will. I mean, particularly for some people, I think powers of attorney are just as important, if not more important than a will. I always tell people, you have an estate plan. The state of Louisiana has an estate plan for you. You may not like it, but you got one. Now, a power of attorney, the tutorship, curatorship process, the interdiction, like nobody really wants to go through that if they don't have to. And so having those powers of attorney in place are like really key. So that's probably, I think, the big one.
Yeah. And I think you just threw out like a few more like
Louisiana
terms.
I was like, exactly. Well, that one's easy because I use a Britney Spears conservator. I'm like, it's like when Britney Spears had a conservator. That's what I'm talking about. And people are like, okay. So I have an analogy, but yeah.
Oh, that's perfect. And such a good point, because I think that's something I like to say too. Like everybody does have an estate plan. You just don't know what it is because it's written in a statute somewhere and you might think it operates a certain way, but even intestacy laws of other states might not work how you expect them to, depending on your family structure, if you're in a community property state. So it's always best to just go through the process, even just have all of your family on the same page and like make sure you all understand. If you choose to share that process with your children, I know people differ on that, but in my experience, it can make everybody's lives a lot easier and stress-free when the time comes to actually like execute those plans. So
yeah, totally agree.
All right. So what I am hearing in this episode is if you are an advisor who has a client in Louisiana, be careful, make sure that they have an estate plan, because not only is it that there are legislatures out there that have made a default estate plan for your client, but in Louisiana specifically, there's also a French flavor to it. And so really your client may be surprised, or their loved ones, if they pass away without an estate plan. And there are ways to work around some of these more rigid rules in Louisiana as well. And so with that, I wanted to close out our episode. Addie, Alaina, thank you so much for joining the Practical Planner. We'd love to welcome either of you back. And with that, for our audience, if you would like more of this content, please, rate, subscribe, and we will see you in a different episode.